Joining me now, the defence lawyer Tim Rustem and Jane Cooper, Operations Manager at Refuge, the domestic violence charity. So we're going to have a new phase, if you like, of a trial with victims speaking out. Is that a good idea?
I think for some victims and sometimes in court, I think it will be helpful. It may be seen as helpful for victims to be able to read their statement. As your introduction said, victim impact statements, victim person statements are not new. They're one of the developments in recent years as everybody has been trying to improve confidence in the legal system.
I mean, what in your view is the purpose, or should the purpose be, of people reading out their statements? Is it to, plea for a bigger sentence against the person who's harmed you or your family, your business? Is it to clear the air, to have your say, to feel you're more included? What is the purpose?
I'd say, contrary to the person who was interviewed in your lead-in, a gentleman who said we can all plead for longer sentences.
Well, his daughter was murdered.
No, that's absolutely not the case. They are a formal opportunity for victims to communicate to the court how the crime has affected them, the impact it has made on them. And government have clearly set out checks and balances around this. Victims are not to be pleading for particular sentences. And so for victims who historically have been absent from trials, trials have been all about the defendant. I think it represents a step in the direction of also ensuring that justice is seen to be done. And I think government have carefully considered how we want to preserve good quality trials, that there has to be a fair criminal process at the same time.
Timur Rustem, do you think this will help the process of justice?
I think it depends what the focus is of this new code. If it's to provide more information, better support for victims, then it's to be welcomed. I think one of the crucial elements of it, to have a right of review where a case is discontinued or dropped, that is important. I think that's probably the most important factor. My concern is, and it's been touched on already, and certainly listening to the language of some of the people, including the Justice Secretary talking earlier on, if it's designed, and it depends on the timing, of course, of the victim's personal statement, if it's immediately at the sentence hearing, I think the danger is you're introducing an emotional pressure to some extent on the judge at a crucial point when you're sentencing. If it comes after the sentence hearing, then of course nobody can really object to that.
But I mean, a lot of people would say, in the case of the man speaking there whose daughter was murdered, if there's emotional pressure on the judge to be a bit tougher, then good.
But that's dangerous territory. You're then effectively making sentencing law. Essentially, the judge has a balancing act. He has to look at the legislation, the guidelines that are given under the law, and then look at the personal circumstances of the defendant, and then apply the law. If you're then introducing effectively an arbitrary measure, which is one person may provide a statement, another may not, and the emotional sort of pressure that brings into the equation, I think is quite dangerous. So it depends on the timing of the victim's personal statement. If it comes after the sentence hearing, I think it'll be largely welcome as a helping with closure, if nothing else, for the victim.
Do you think there'll be a large take-up of this chance to make a statement? I mean, as I understand it, at the moment, only about 1 in 10 of victims actually write a statement that the judge then reads. Well,
sadly, victims of violent crimes, domestic and sexual crimes, have great difficulty accessing support services. Support services are being closed every day of the week, so they're often have minimal support through the proceedings. Refuge supports 3,000 victims at any moment, 3,000 women and children at any moment, and on any day of the week we'll be assisting a victim somewhere who wishes to make a victim personal statement. I think judges are big enough and seasoned enough to be dispassionate and give careful, objective consideration to all the evidence that's brought before them. The matters they're hearing and having to decide are inherently emotive. Crimes of rape, crimes of serious domestic violence. It should be said
that, I mean, this also applies to businesses that are, I mean, there are more businesses that are victims of crime, I think, than there are individuals.
I don't personally think we need to protect judges from getting a bit emotional as they judge a crime. And I think that there is a place for victims to be able to make these statements, subject to the checks and balances that government have built in, and for us to redress this absence from victims in the justice system.
I think the suggestion that victims don't have a say is wrong. I mean, they clearly do at the moment. A victim will come to court, will give evidence that will be heard by the judge, who will bear that in mind when it comes to sentence. On top of that, we have victim impact statements already being given, and you have a discretion by the prosecutor and the judge as to which elements of that are to be read out and taken into account. I think the danger is that if you introduce a system where at the moment there's about a 9% take-up rate, where in one case you may have a victim come into court, deal with this in terms of providing a statement, another case where you don't, for very similar offences.
I mean, would the statements be vetted in any way before they're given? Is that
There's a formal process for submitting statements and for what can and can't be included. You can't send in a statement and say, lock him up and throw away the key.
So that might not give people a satisfaction
Some people
that they're
will be very
looking for.
disappointed, I'm sure.
If this is about tougher sentences, that's a separate issue, and that should be dealt with through a change in the legislation and sentencing guidelines issued down to the court. I think it's very dangerous if we use this, as some of the people have said already, to bring a greater sort of balance to the sentencing process. I think if it's about information, assistance, support to the victim, it's to be welcomed.
Okay, thank you both very much. Thank you.